As promised, I'm joined by legal professional lawyer Eugene Wamalwa, who is also the DAP Kenya party leader. It's been a busy couple of weeks with regard to the impeachment of Gachagua as deputy president. If you don't mind me asking, you visited him in hospital today. What's his condition?
Last night when he was admitted, he was in quite a serious condition. He had serious chest pains. And Dr. Gachagua told us he was under extreme stress. And had he not been admitted, he was actually running the risk of very high blood pressure that could have led to a stroke. So his admission was timely, and the team managed him very well overnight. They could not allow any visitors last night. We were all going there, but we were told no, only the family would be allowed. This morning, they were very gracious to have allowed myself and His Excellency Kalonzo Musyoka with a few senators who were able to get to see him, and he had stabilized. But he was still very weak, he couldn't talk much.
Okay, but you did speak to him?
Yes, we did speak to him, and we encouraged him. And he did tell us that he had sent his lawyers to court to fight for him because he wanted to be heard. Just the way he was heard in the National Assembly, he wanted to be heard by the Senate. If you do recall, when he was given an opportunity to take a seat, he said, no, I want to stand. And he was determined to face his accusers on his feet rather than on his seat or on his knees. That was a man who was prepared to face the nation and tell them his truth. He's a truthful man, and all he wanted was a chance. But he was denied that chance.
But here was the Senate faced with two constitutional imperatives. Yes. One, that the deputy president shall be heard. Yes. But also there is a provision that the committee that hears the impeachment motion has to dispense with it or submit a report within 10 days. Yes. What do you make of the decision they took?
I think there was some unnecessary hurry. I don't know where Kenya was going. It's like there were some deadlines that were not constitutional. If you look at the National Assembly, they had like 7 days to do this. And they were able, from the day of the motion, to dispose of it so fast. They had 2 days to actually relay to the Senate. They did it in a record time overnight. Then when you look at the Senate, when you form that committee, they had 10 days. But you could tell there was such urgency, as if they had been told by the stroke of midnight, the deed must be done. You must do away with that man. And there was no reason why they could not have adjourned to Saturday, because they were still within the period. But that's for a special committee. But when it comes to plenary, there's no limit. Because this is a quasi-judicial body, the Senate was supposed to act in a judicious manner. They would have allowed the deputy president to be attended by his doctors and to come back. He didn't show any sign of not wanting to be heard. He faced on his feet all the charges, and he wanted to defend himself.
But he did want to be heard on Tuesday, which would have been outside the timeline of Saturday midnight. But the courts have essentially pressed pause. Yes. On the entire process.
Yes, because, and I must say, really, when you look at the way Parliament has acted, including the sitting of today from last night, it's like they had orders from above.
So the timeline will definitely come
Yes,
up.
by midnight it must be done. The Speaker could have said, being a lawyer, you're acting as a jury, you must be judicious. Let's allow this man time on Saturday. Let him come back.
That was his proposal initially.
Yes, it was, but
it was
still,
voted down.
under Standing Order 1, he had the powers to make that ruling. But obviously, he like Pontius Pilate, he washed his hands and threw him to the wolves. Literally, it's like a lamb to the slaughterhouse, like the Bible says, or a sheep to the shearers. And I had told my friend Rigathi Gachagua that ukiona mwenzako anyolewa kichwa chako tia maji, hakuweka maji, alinyolewa bila maji. It was very sad what happened. They could have extended. Kenya was not going anywhere. And the limitation was to the committee. But this was the plenary. So it could actually
So that is one of the issues that will come up in court.
Yes, it's one of the issues. And in court, when you talk about justice, there are two basic principles of natural justice: that a man shall not be condemned unheard. The second one is that you can't be a judge in your own cause. And in this case, when you look at the speakers of both houses, they were interested parties. They were biased. Like Speaker Wetangula, ahead of the impeachment hearing, he made a statement in Machakos, if you do recall.
I recall, but I don't want to prosecute.
He did say, no, if you...
I don't want to prosecute the issues that will be had by the courts, but there are those who have taken the view that the courts are interfering in a political process by staying the swearing-in of Kithure Kindiki as deputy president.
It's not a political process, Olive. When we transform the chamber into a judicial or a quasi-judicial organ, they must act judiciously. And they're serving justice. It's not about politics, it's about justice. And it's about affording the other party the opportunity to be heard and to defend themselves. This was denied the deputy president, and of course, having attended religiously when he was called in the National Assembly, in the Senate, he was never late. So something happened, and his doctor said that had he not been admitted, the levels of stress, because this was like the last day, even the Son of God, when he, in the Garden of Gethsemane, when he faced that day, he was very stressed. And he said, Lord, if you may pass this cup of suffering. He was the Son of God. This is just a son of Mau from Matira. He almost broke down. So what we are saying is that, what kind of a nation are we that we could not allow a sick man a day or two to come back and defend himself? What was the hurry? And this is where we are saying, if we are a country under the rule of law, we must respect the tenets of the rule of law and justice. And the basic, most fundamental are the principles of natural justice. We condemn them unheard.
But wasn't this, at the heart of it, a political process? What of the separation of powers?
Yes, the separation of powers were respected by the court. If you do recall, there were over 20 applications to stop Parliament. And that judicial restraint was exercised in the sense that the judiciary cannot injunct Parliament. But now Parliament did their role, and they were not judicious enough. They denied the accused person.
In your view?
The right? No. He was denied the opportunity to defend himself. And that is why
But Parliament would argue that they had scheduled time for him to defend himself. He did not turn up.
Yes, but I have been a member of Parliament. There were days when Speaker Marende fell ill, when Speaker Ole Kaparo fell ill. You cannot dictate a man's health. You have no powers over that as a human being. And this is why we're saying, we can't be really so lack compassion as a nation to the extent that we could do this, when all we could have done is allowed him to defend himself. But thank God, the judiciary is there. And under Article 159, the judiciary draws its powers from the people. And under Article 160, they have the independence. They're not answerable to the president. Now, when you look at the Parliament, the way they acted, the periods given, the way they fast-tracked everything, including anticipating debate before Gachagua appeared before themselves, from the Speaker to the Deputy Majority Leader to the Whip, they had already made up their minds. You come to the Senate, there was the issue of shareholding. Both speakers of the House were interested parties. They could have recused themselves. And one of the members requested the Speaker, now that you've already pronounced yourself on this matter, why should you be in that seat? How could you preside over a case that you've already made up your mind?
Speaking of shareholding,
yes.
You had, as Azimio, condemned the terminology of the country is a company and their shareholders. What did you make of the grounds of impeachment? It was the first ground, and he was impeached immediately.
Yes, and what we are saying is really, there's a lot of hypocrisy about that. Because actually, the leader of Kenya Kwanza is William Ruto. The gospel of shareholding was the gospel according to William Ruto, not Rigathi Gachagua. He's just an assistant. When you look at the signatures that appeared on the document of how they were sharing and their shares,
so you buy
they are signed by William Ruto, signed by Moses
that this was about
Wetangula.
shareholding of power.
No, signed by Musalia Mudavadi, signed by others. In fact, there's only one person who signed who didn't get a share. My kid brother, Chris Wamalwa, he's the SG of Ford Kenya. In fact, he was asking Wetangula, what happened to my share? Ulikula share yangu? You know, these are things that we are saying, what's good for the goose is good for the gander. If you are saying, Ruto stood in Murang'a and said, my people of Murang'a, you are my main shareholders, then Rigathi, the only problem that Rigathi has is that he was overzealous in terms of preaching the gospel. But he's a disciple. When it comes to crucifixion, they crucified Jesus Christ. They didn't crucify Peter or James, the disciples. In this case, we have crucified a disciple of William Ruto.
Okay, so where are we
when
now?
you look at the beginning of the gospel of division, started from the hustler versus dynasty. Ruto said, I'll be the president of the hustler nation. He's never been the president of the Republic of Kenya. He sowed the seeds of division from the start. So how do you separate Ruto from Gachagua?
All right.
Then you crucify a disciple and you leave Jesus Christ himself.
Legally, where are we? We have Kithure Kindiki, and you'll come back and tell us
Yes.
as we wind up
Yes,
what you make of his nomination and approval by Parliament. But we have Kithure Kindiki, who has
Yes.
been approved by the National Assembly. Wetangula says this is a deputy president-elect. We have Rigathi Gachagua, who has been impeached, but the courts have stayed the process.
There's no problem with Kindiki being nominated, but what we are saying is that the process, the rule of law, justice must be followed. Now, the president had 60 days. The president had 14 days to nominate. Why is it that the law provided for 14 days? Because when you nominate someone who is going to be elected, Gachagua was elected by 7 million Kenyans. Now, you are giving a role of elected representatives. Before they vote, that person must be verified by IEBC and other institutions because he must have the qualifications of a president.
As per the letter of nomination, he has been cleared.
Yes, but what we are saying is that by midnight, last night, when Gachagua was impeached, and this morning when the letter came, are you saying the president was able to meet IEBC, and we don't have an IEBC, meet KRA, meet EACC, and get the clearance by morning?
But would he be meeting them in person?
Kindiki to be cleared by morning. When did the president meet all these people? We don't have an IEBC. So we are saying today that this more than meets the eye. You have 14 days, you take less than.
But is he a good choice in your opinion?
No. It's not about the person. In fact, this is not about Gachagua. It's not about Kindiki. It's about our constitution. And between us and anarchy is our constitution. And between us and anarchy is the judiciary. Because when you look at the way Parliament has been harried through this process, what should have taken 14 days in terms of nomination took hours. What should have taken 60 days, Parliament to approve, took less than 10 hours. And we are saying there's more than meets the eye. Why are we hurrying? Where is Kenya going? It's because we have been told one man has said by Sunday, when you go for Mashujaa Day, I don't want that man next to me. I want a new deputy. Then, Parliament says, if you were told jump, you say how high? If you're told, can you do this? You say how fast? Parliament is supposed to be independent. Now, this is why we are saying Parliament has been captured, and God forbid if the judiciary, and we thank the judges in Kerugoya, we thank the judges in Milimani, who made the orders to preserve our constitution, to conserve the status quo. And tonight I want to say this, as the last Minister for Justice, William Ruto, if you listen to me tonight, please, you have disobeyed all court orders. Don't disobey this one. Allow the courts to hear this matter. Even if you have, 60 days should have been given. Allow this matter to be heard. Kenya is not going anywhere. You might hate Gachagua. You did the same to Uhuru Kenyatta. Uhuru never removed you. Uhuru put up with you for 4 years.
I'll have to press pause on the conversation
very
at
much.
that point. Thank you for joining me tonight.
But Olive, before you conclude, you know,
In a
the
minute.
CJ has called for the 24th of October for the hearing.
Yes.
All we are asking that between now and then, because we know there are efforts to force the courts to sit at the weekend, at night, to overturn the court orders, we are urging William Ruto and his Kenya Kwanza Brigade, if you respect the rule of law, respect the court orders.
Is that really the case, that they're being forced to sit at night?
There are pressures and the judiciary is being intimidated. I want to ask the Chief Justice, between Kenya and anarchy is the judiciary. Let justice be our shield and defender. Our parliament is captured. We have an overbearing executive. Don't give in to that intimidation.
I think let justice be a shield and defender is a good note as any to press pause on the conversation. Thank you for joining me tonight. Eugene Wamalwa of the Azimio Coalition, party leader, Democratic Action Party of Kenya. As you heard him say, last minister for justice, as well as serving in various capacities in Uhuru Kenyatta's administration. We take a break, but coming up,